Welcome everyone to our webinar on managing stress and workload, employer responsibilities under workplace health and safety laws. My name is Saeidul Haque and I'm a senior associate in the employment and health and safety team here at LegalVision. And today, before we begin, just a quick couple of housekeeping items as well. So we will be recording this session today and you will be emailed a copy of it. So if you do miss anything, don't worry, you will have a chance to look back at it later on. I'll also be taking some questions from you at the end of today's session, so please do submit them throughout this webinar in the Q&A box you should be able to see on your screen, and I will try and answer as many of them as I can at the end of today's webinar. And finally, there is also a survey at the end of this webinar, and I would be grateful if you could complete this just to give us any sort of feedback. So just a quick poll question that should come up on your screen, hopefully, just before we begin. So I wanted to find out really what part of this webinar perhaps is going to be most interesting for you. So in terms of the question, is which part of managing stress and workload are you most unsure about? So the first option is what mental health means in a workplace context. The second option is understanding your legal obligations under health and safety laws, how to manage employee mental health and workload effectively, the procedures and policies that every business should have in place, all of the above, or perhaps you're not sure and you're just here to learn. So just give you a minute, just have a think about that. And I'll just repeat that question again in case anyone missed it. So which parts of managing stress and workload are you most unsure about? The first option is what mental health means in a workplace context. The second option is understanding your legal obligations under health and safety laws. The third option is how to manage employee mental health and workload effectively. Fourth option is the procedures and policies that every business should have in place. The fifth option is all of the above, or the final option is that you're not sure and you're just actually here to learn. Okay, so I think that should have given you hopefully enough time to answer that question. So if I look at the scores then, so it seems like most of today's participants are keen to understand their legal obligations under health and safety laws. So hopefully I'll be able to answer that question for you today and give you that clarity. So before we begin then, for the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. So to claim this consultation, please do provide your contact details in the survey at the end of today's webinar. So in terms of today's content then, so we will be discussing what is mental health in the workplace, legal obligations that you owe to an employee, managing employee mental health and workload, and finally, procedures and policies as well. And as I said beforehand, at the end of today's session, I will be addressing some of those questions that you have as well that you can submit throughout today's webinar. Okay, so let's get started then on today's session. So what is mental health? Well, mental health is really our state of mind, and it includes our emotional, psychological, and social well-being. And it's something that we all have, just like our physical health as well. And you may be thinking, well, why is it important? Well, the reason why it's so important is that mental health can really influence the way we think, the way we feel, behave in any sort of day-to-day activities that we carry out. And it can affect really everything from our decision making to our daily interaction with others, including our colleagues. So ultimately, it is important to both monitor and look after our mental well-being, which is just as really important as our physical health, I would say. Now, when it comes to mental health, it can be affected by a variety of different matters, and it can also affect every individual differently as well. But often, what you'll find is that it stems from long term ailments such as depression or anxiety. but it can also stem from other life events such as a bereavement or perhaps familial issues or, for instance, a divorce as well. So all these things can have an impact on any individual, to be honest. Now, in circumstances where the mental health condition, is long term, then an employee can be legally deemed as disabled under the Equality Act 2010. So that's really important to consider, and I will touch more on this later on. Now, poor mental health itself can have its roots in other forms as well, such as physical health, personal circumstances, finances as well, and just general appearance as well. You might see a deterioration in someone's appearance over time because of issues they're facing in their personal lives. Now, in the workplace specifically, poor mental health can also be influenced by excessive workloads or management relationships, job insecurity, and also workplace conflicts. And not all employees are going to show obvious signs of poor mental health. And also, with the rise in remote working, this can be even more difficult to identify. But some of the key changes you may want to look out for would be changes in the work quality delivered by an employee, perhaps the communication style. You might have noticed someone who was quiet before who was more direct, assertive, maybe aggressive, perhaps as well, or just general engagement levels. These can all be early indicators. As an employer, what you should be looking to do is considering regular check-ins with employees to see how they are, and the employee should be encouraged to speak about their mental health openly as well. And again, this includes remote work as well. We should be regularly having catch-up meetings with them as well. And this can just form part of a general catch-up between a manager and an employee. So it doesn't have to be anything sort of specific that is just purely speaking to an employee about their mental health. It can be just part of a general catch-up with them where you talk about performance. You might just ask, at the start of the session, how the employee's feeling, how they are in their general life, if there's anything that you can support them with, or if there's anything that you should be aware of as well. And of course, the contents of that discussion should be kept confidential so far as you can. Now, beyond this, you should look to foster an environment whereby discussing well-being feels as natural as discussing project deadlines, and that could include training managers perhaps to ask the right questions, to listen without judgment, and also knowing when and how to signpost employees to appropriate support services, including employee assistance programs and other external help. We'll touch more on this later on in today's session as well. Now, when it comes from a legal obligation point of view, well, employers, legally speaking, owe a duty of care to employees and must, so far as is reasonably practicable, carry out risk assessments to identify and control any issues, protect staff from discrimination in the workplace. You should ensure workers have a safe working environment. You should also ensure that you create a supportive environment. You should monitor and review workplace mental health policies regularly. And finally, you should also try and provide help and support where it is identified or where an employee perhaps comes to you for that support. Ultimately, protecting staff from discrimination is important, and failing to do that can lead to complications for the business, mainly in the form of an employment tribunal claim against the company, but it can be in other forms as well. Now, one of the main sort of legal obligations as an employer is under the Equality Act 2010, and that's to consider reasonable adjustments for your members of staff to try and remove or reduce a disadvantage related to someone's disability or health status, generally speaking. Now, a long-term condition can amount to disability under the Equality Act, and that includes both physical and mental health ailments as well. So whether that's, someone who has physical disability in the sense of, perhaps they're in a wheelchair, or mental health ailment where they're suffering with depression, anxiety, PTSD, or some other form of mental health ailment, reasonable adjustments ultimately need to be considered when you know or are reasonably expected to know that someone is disabled, or when someone comes to you and asks for those adjustments. So it may be in the case of the catch-up that I mentioned before, and an employee may say to you that I'm really struggling with my mental health. and you might then start to think about adjustments for that particular employee. Now, when it comes to adjustments, it should really be considered for any employee who needs them, but it should also be considered perhaps for parties that are not your employees, so job applicants or visitors to your premises. So with job applicants, when you advertise a role online, what you might do is put a small statement or a paragraph in the sort of advertisement that if an employee has a disability that requires reasonable adjustments, that they should notify you as part of their job application. And typically, an adjustment there would be perhaps additional time during an interview so someone can compose themselves or just be able to answer the question. They may ask you to provide interview questions beforehand if they really suffer with certain mental health conditions, or maybe other forms as well. Ultimately, what you want to do is try and consider those as best as you can. And as long as they are reasonable, then you should consider making those for that individual. When it comes to visitors to your premises, the obvious one perhaps may be that you might have a ramp for those with wheelchairs, and maybe a lift, or maybe other sort of ways in which you can assist a physically disabled individual. Now, when it comes to employees, the adjustments that you may want to specifically think about would be perhaps a changes to an employee's working pattern. So that could be, their working hours, typically, you would see this perhaps as sort of a phased return to work after an absence, usually a long-term one, where you might agree that the employee can work less hours. If they work 40 hours, they might work 20 hours, just get them back into the swing of things, then escalate that to 25 to 30 to 40, ultimately getting them back onto those full-time hours as well. You might also want to consider allowing friends or family to accompany employee to a meeting, whether that's a formal meeting or an informal meeting, just for that emotional support. Or you might want to consider amendments to certain policies, such as an absence management policy for those with long-term health conditions. That's more sort of geared towards employers, perhaps who are in today's webinar, who have like a Bradford Factor score where they score employees based on illnesses, absences, where you might have trigger points where if someone has a certain level of absence that it will trigger a meeting with that employee as well. Now, when it comes to long-term absences and health conditions, long-term health conditions, you want to consider perhaps discounting employees in that situation, because if you don't do so, you might be faced with a situation where you are actually discriminating against an employee. Now, in terms of employees, ultimately, it is important to make sure that staff are aware of their responsibilities as well, and to try and support any employees who makes a request for workplace adjustments, because, as I say, a failure to make those reasonable adjustments could lead to a claim for disability discrimination in the employment tribunal. And if you are faced with that type of situation, compensation in the tribunal really depends on the severity of the alleged discrimination, but it is worth noting that an award can be uncapped in certain circumstances, and in other circumstances, it can also lead to personal liability for individual employees. So ultimately, you want to be really careful with the way you sort of treat mental health in the workplace and the way you consider reasonable adjustments as well. And also, I guess, to add to the tribunal side of things as well, if a claim was successful, it can lead to negative publicity. You may have seen stories recently in the newspapers about various employers. So it can have that reputational damage, given that employment tribunals are conducted in public, generally speaking, and the outcomes are delivered publicly, and they're available publicly online as well for anyone that wants to read them. Now, one of the important parts to think about from a legal perspective is a mental health episode. So, you might have a situation where an employee suffers from a mental health episode where they begin to act differently. And if you ever believe that an employee is suffering with a mental health episode, then you should consider contacting the emergency services immediately, particularly if you believe that employee may be at risk to themselves or to others. If it's not urgent, then what you might want to consider doing is asking the employee to contact NHS 111 online or call in 111 themselves, or yourself as the employee. You can look to do that as well. Typically speaking, your HR and senior management team should be notified of any sort of mental health incident, and that should be documented and kept in the employee's personnel file in case you need to rely upon it later on. Now, a sign of mental health episode would typically include panic attacks. It could include physical confrontations between the staff and others. It could be substance abuse at work, irritability perhaps. Sometimes you might have an employee that's particularly confused, or there might be some sort of self-harm reference, including the mention of suicidal thought. So it is important that as an employee you do act carefully and quickly as well, depending on the situation. And as I said beforehand, mental health may be classed as a disability in the Equality Act, depending on how it manifests itself in that particular employee and how it affects them. And you should consider those reasonable adjustments that we mentioned beforehand as well. Or what you want to consider really is that the employee's well-being and safety should always be a priority, while also equally maintaining confidentiality as far as you can. And when you have a situation where you do provide that support to an employee's mental health, you will firstly, of course, fulfill your legal obligations. But I would say you would typically have the added benefit of reducing absences and also increasing staff retention and productivity in the workplace, which is ultimately what I would say is the goal and objective is there, mainly speaking. The key here is trying to intervene early and trying to take that proactive approach as well. Now, managing an employee's mental health and workload can be challenging, but allowing an issue to foster can create issues such as persistent absences, changes in behavior, and disinterest perhaps in the work itself. The sooner an issue can be spotted, the quicker a resolution can be sought. Now, spotting the signs of poor mental health is difficult. It's not everyone will show obvious signs, particularly for those who work remotely. Now, you're not expected to medically diagnose your employees, but what you are encouraged to do is encourage staff members to be open with you and to be honest about how they're feeling and to provide that reassurance to them that there will be no judgment and that appropriate support will be given to them if they are suffering with their mental health. Some indicative signs of poor mental health can include a change in the standards of work. So you might see, a high performer previously. You might see the levels of performance drop quite dramatically. You might see an employee suffering with low mood, just lacking energy, generally speaking. They may be suffering with anxiety, or they might be, particularly tearful as well. The key here is to try and offer that support to an employee because it can release that reduction, as I mentioned before, in absences, but also better performance at work and also how the employee feels in themselves and how they feel about the employer as well. And conversations through regular meetings between a manager and employee may be sufficient, or a specialist help is required. You can consider instructing an occupational health professional with, of course, the employee's consent or arranging employee assistance via third parties where they can consider receiving confidential counseling or therapy. So, what do those sort of external programs look like? Well, EAP or an employee assistance program is essentially an employment benefit that some employers do provide. It's not a legal requirement for you to offer this to your staff members, but I would say it can prove beneficial, particularly when that specialist assistance is required or where perhaps an employee might feel more comfortable speaking to an external party for support. An EAP provider would typically operate a confidential helpline. Most of them, I would say, are sort of 24/7 that the employees can contact to discuss any issues, whether that's something happening in their work life or in their personal life. So that could include the EAP provider supporting the employee with domestic violence issues, bullying and harassment in the workplace, debt or other financial issues, or familial disputes as well. And typically, that advice given by the EAP provider will be given by a specialist. And I would say it's quite practical and empathetic to the employee's situation as well. And the goal really is to try and support the employee in managing their mental health and to provide them with any necessary tools or further reading to help facilitate this. In some circumstances, it can also lead to referrals to further specialists. So that could be with cognitive behavioral therapy, for instance. Occupational health assessments are another external piece of help that you can seek, and these are essentially a type of medical service provided by an occupational health provider and GPs as well. The aim of these types of assessments are to assist you in understanding an employee's condition or ailment, and the assessment would usually involve a consultation between the employee and the occupational health specialist before a detailed written report is drawn up, which is often shared with the employer as well. Now, the report itself is typically quite practical and can include recommendations and guidance to you on whether the employee, firstly, can be legally be deemed to be disabled or not, whether any sort of reasonable adjustments can be made, and if so, what they are, specific workplace risks that may affect the employee's condition, the likely timescales as well for recovery or adjustment periods, and also whether or not redeployment or alternative roles should be considered perhaps as part of a formal medical capability process. Now, occupational health assessments can only be obtained with the employee's consent, and all the medical sort of information that you obtain would remain confidential. But as long as they provide their consent for the report to be shared with you, then of course you have the benefit of reviewing that, and they can be used in the case of long-term absences or where an employee discloses a mental health condition. What I would say, from my experience is that the main sort of difference between a GP report and a medical report is that a GP report, I would say, typically sort of sits on the fence, doesn't give you a definitive response in terms of whether or not someone is disabled or not, or is likely to be disabled or not. And they don't always provide the most practical solutions. Whereas an occupational health report, while I would say is more expensive than a GP report, they usually don't sit on the fence. They do give you a definitive response as to whether or not they consider the employee to be disabled, and they typically give you quite practical solutions and give you a realistic prognosis period as well in managing that. Whereas GPs, perhaps they might be more willing to sit on the fence because they probably have that personal relationship with the employee themselves. Now, another thing you can consider is a stress risk assessment. So these are different to a general workplace sort of risk assessment in that they would be used to identify any sort of workplace stress and triggers for perhaps a particular employee or just generally within your workplace for your employees. Now, to carry out a stress risk assessment for an employee, what you would essentially need to do is follow a systematic step-by-step process to try and identify, control, and mitigate risks in the workplace. And what you would be doing as part of that assessment is observing the work environment and considering how the employee or your employees work, including their workload, deadlines, are they manageable or not, work patterns, and just general relationships with colleagues as well. You would also look to assess the job demands, such as the work pace, the complexity of the tasks given to employees, any conflicting priorities and time pressures. And you would also look to evaluate workplace factors, including management style. Is there ways in which we can change that to better deliver a message? So communication patterns would be key there. The level of support perhaps available to an employee, are employees actually aware of the support available? Because often they're not. Job security and also the opportunities for development. Individual factors that are relevant should also be considered, such as an existing health condition and personal circumstances. You might have an employee who is going through a divorce where they might be really up against it. So that's going to be really different to someone who's perhaps suffering with mental health because of different reasons, maybe a bereavement, for instance. What you try to do really is you want to try and eliminate or reduce the stresses where possible, of course, and where it's reasonable, and implement practical steps to do this by perhaps redistributing workload if someone is really put against it, adjusting work deadlines. Can it be managed with the employee directly? Can we liaise with our clients and adjust that and prioritize the immediate high priority needs, and the lesser so priorities we can deal with them perhaps at a later date? And perhaps as an employer, you might want to consider providing training as well to your members of staff, which might help them in managing their workload and their time more effectively as well. And all of this should be sort of be considered as finding as part of the risk assessment and compiled into a detailed report as well. And what it would do is really set out the stress hazards you've identified, the staff members that may be particularly affected, and the control measures that you have put in place or will put in place to manage that, and ultimately to try and find a viable way forward for the employees as well. Now, risk assessments generally and workplace risk assessments for stress should be regularly reviewed and updated where required. And it's particularly important where there is a role change or any sort of potential new stresses, including incidents perhaps in the workplace or any sort of organizational change. Maybe there's, someone that employees really looked up to that's left the business. You might want to try and plug that gap to make sure that doesn't foster into a larger issue. And really, that whole process with the risk assessment should involve consultation with the employee that's particularly affected or employees, generally speaking, to ensure that their concerns are properly understood and addressed as well. So it's a collaborative effort. Now, more and more, we're seeing mental health first aiders and mental health champions in the workplace, particularly, I would say, among the larger businesses. So, what are the differences? Well, a mental health first aider is really an employee who is specifically trained to try and recognize signs and symptoms of common mental health issues. And the intention really is for the first aider to be part of, uh, I guess, to be the first point of contact for supporting employees before directing them towards appropriate support, whether that's internally or externally. And typically, a first aider, a mental health first aider, will have a qualification in mental health in the workplace, similar to first aid in the workplace that may be given by St. John's Ambulance or other training providers. And really, a mental health first aider should be someone who has strong interpersonal skills, I would say, and a strong understanding of the need for confidentiality and sensitivity as well around these issues. With the role of a mental health champion, I would say it's similar to a mental health first aider, except they don't need to have any sort of specific qualification in mental health at work. And typically, you're going to see HR managers, general managers, and supervisors taking up these roles, whereas mental health first aiders can be anyone really that has that qualification I mentioned. Now, the champion would really try to focus their attention on raising mental health awareness in the workplace generally to try and normalize the topic. They would try to promote positivity and preventative approaches in terms of mental health, seek staff feedback on mental health improvement, and really being available to provide support to employees. Finally, it is important to note that you are responsible for the mental well-being of any staff that work from home. For these workers, it can be difficult to spot signs that there may be irregular contact, but it is important, and I would say it would be prudent to have that regular contact with them to just check in to see how they are and how they're doing, how they're feeling, and to address any issues. As I say, the main objective being to prevent issues fostering into becoming much larger issues. Prevention is easier than a cure ultimately. Now, to support the staff, the following procedures I would say should be considered and it can be incorporated into a staff handbook or other handbook, depending on how you operate. So, anti-discrimination, I would say, is a given for most employers because these types of policies make it clear that a staff must not discriminate or harass other people, including employees, and that could be due to their mental health or could be due to another protected characteristic. That could be someone's race, religious beliefs, it could be philosophical belief, so on and so forth. It's important that we don't discriminate against anyone. Another policy that would be important would be an anti-harassment and bullying policy, and this can be used to really confirm that you're committed as an employer to provide in a workplace environment that is free from harassment and bullying, and to ensure that all staff are treated and that they treat others as well with dignity and respect. A whistleblowing policy can be useful to support staff who wish to make a complaint about any sort of suspected wrongdoing, and it also allows them to understand how they can raise an issue confidentially without fear of reprisal. A grievance procedure can also be considered for your employees, and that can be used to deal with any issues quite swiftly and formally, and perhaps to enable, in some cases, for issues to be dealt informally as well. Disciplinary procedures, of course, are a given because they need to be well, they would be important in setting out the potential repercussions for those that breach your policies. So any of those that I've mentioned, or any of your sort of workplace conduct policies as well. And that's particularly important in case, anyone bullies or harasses employees that suffer from mental health ailments or any other, if they have any sort of other protected characteristics. And they would usually be useful in acting as a deterrent and demonstrating to offenders that these matters will be dealt with seriously and it could lead to a dismissal in certain circumstances. A mental health policy, I would say, is important, is in sort of being useful in setting out the support available to staff members, including internal and external support. And it would also be useful in setting out how the organization deals with mental health issues and its importance in the workplace. And then finally, a remote worker or a lone worker policy would be helpful in addressing the unique mental health challenges faced by those who do work alone or remotely, and it can be used to establish clear communication channels with those employees with the aim to ensure that they have equal access to any mental health support services. And that will provide them with that reassurance and reduce any likelihood of them perhaps feeling isolated or abandoned. So that really concludes the main part of today's webinar, but you might find our publication on how to hire and inspire in the UK useful. So if you want to download that publication, please feel free to scan that QR code and you can go ahead and take a look at that and have a read of it. We also have an upcoming webinar that may be of interest to you in terms of the employment side of things. So our next webinar on employment topic would be on Tuesday, the 9th of September at 11 a.m. PST. And that would be all about flexible working in 2025 and what employers need to know. And if you would like to register for that webinar, then do please feel free to click on that link shown on the screen and you can register your interest. So we're going to answer your questions shortly, but while you do continue to submit them, I'll just take you a minute just to tell you a little bit about LegalVision's membership. So by becoming a LegalVision member, your business would get unlimited access to our full team of 100 plus specialist lawyers for all of your business as usual legal needs. I would say it's like having your own in-house counsel for a fraction of the cost. And our team can assist you with a lot of different legal needs, including unlimited document drafting and reviewing, whether that's business contracts, employment contracts, or otherwise. It would include unlimited legal advice consultations on a variety of different areas, and it would also include unlimited domestic trademark registration and much more. As a LegalVision member, you don't need to worry about the cost of lawyers again. And as I say, it's like having your own in-house legal counsel because we'll take care of the business as usual legal work, and you can focus really on the important things, perhaps for your business, which is your general day-to-day running of the business. And if you are an in-house legal counsel on this webinar, then we do also offer a support service dedicated to those types of individuals and businesses, and that would allow you to manage your high volume business as usual legal risk as well. To learn more about membership or desk extension that we can assist you with, please do request that free consultation when the survey appears at the end of this webinar. And now I'll move on to some of the questions. So let me just have a quick through about what has come through. So we've had a great question come through here about what is meant by PCP, and can you give an example, please, of that? So a PCP basically relates to a provision, criterion, or practice, and this mainly is in relation to discrimination, specifically indirect discrimination. So sometimes you might have a situation where you put in place a policy as a business that indirectly affects others. So it could be something as simple as you have a policy that says that staff cannot wear headwear in the workplace for health and safety reasons, but that might indirectly affect those with particular beliefs. For example, someone might have a religious belief where they have to wear a headscarf or a kippah or a turban or another sort of religious garment. By having that provision, criteria, and practice in place, you are potentially indirectly discriminating against those individuals. But if you can objectively justify that, then that's something you can potentially look to utilize. But I would recommend seeking legal advice before you do so. Another question then what we've got is, well, let's have a look. There's quite a few here. Let's see which one. What is discrimination arising out of a disability? So another great question there then. So Discrimination arising out of a disability is a form of discrimination, and discrimination can come in many, many forms. So we've got direct discrimination, we've got indirect discrimination, we've got harassment, we've got victimization, perception-based, so on and so forth. And one of those types is discrimination arising out of a disability. And that's where you have a situation with an employee who is perhaps particularly disadvantaged because of something that arises as a consequence of their disability. And that could be, for example, if you have an employee with a mental health condition, let's say PTSD, for instance, there may be, as a consequence of that, that they conduct themselves in a certain manner. Maybe they're a little bit more aggressive. Maybe they consider that to be assertive, but that may be as a consequence of that PTSD that they suffer from. So we do have to be mindful of that and consider whether or not we can make reasonable adjustments to accommodate an individual in that sort of circumstance. I do hope that answers your question there carefully. Let's see if we can answer a couple more questions then. So I've got another one that's popped through here about um, what is the employee's responsibility to manage their stress and workload? Okay, that's another great question actually, because under health and safety laws, employees as well as employees have a duty to be responsible for their own health and safety and that of others as well. Now, employees, therefore, to a certain degree, are responsible for managing their own stress and, of course, naturally, their own workload. And that would usually mean they need to follow workplace policies, any sort of reasonable instruction given to them by the employer, reporting any stress or concerns that they have with their workload as well to the employer as well. I mean, ultimately, the employee should try to engage with the employer, I would say, so far as they can. And that includes, if the employer is trying to make reasonable adjustments to accommodate the employee or trying to make referrals to a third party like an occupational health provider or another type of specialist as well. But what I would say is, sometimes you will have a situation where an employee can't really be expected to manage their workload because it might be genuinely excessive. So employers, I would say, generally speaking, should know how much, work roughly an employee has on their plate and whether or not it's manageable as well. If it isn't, then they should consider whether they can delegate the work to others. The primary responsibility, I would say, ultimately still lies with the employer. So hopefully that answers your question there too. Let's see if we can answer a couple more questions as well. Um, so someone's asked a question here about how do you know your employee is genuinely suffering with a mental health problem? So this is a common sort of, I guess, position employers are faced with because it can be quite a difficult thing to establish, not only for employers, but also for medical professionals as well. Because how can you tell, what someone is saying to you about how they feel about something is truly how it's affecting them? And the short answer is, we don't really know, to be honest. But you're not expected to medically diagnose an employee like a medical professional. What you are, I would say, expected to do as an employer reasonably is look for telltale signs. For example, has there been a change in the employee's mood? You might have someone who's happy-go-lucky, and all of a sudden, they're as dark as the day comes. And they may have a mood. There might be that sudden behavioral change. It's important that we speak to the employee to find out, if there's something going on in their personal life or otherwise. You might see a drastic change in someone's, performance. You might have a top star performer who's suddenly the worst performer in the business. You might have someone in the sales role who's really good at sales and ultimately just drops off dramatically, even though they're doing the same things. Maybe the way they're doing that because of the way they're feeling is affecting that as well. And a lack of concentration can be another big one, I would say, as well. You might see someone who's making mistakes that are easy to rectify, whether it's typos, the way they speak to your clients, or otherwise as well. I would say ultimately, you're not there to try and prove that they have a mental health condition or disprove that someone is genuinely suffering with something. You should try and take the concerns at a face value initially. And if ultimately you need further assistance, then you should consider really obtaining a GP report or an occupational health report with the employee's consent. And the focus should be on supporting that employee rather than investigating whether it's genuine or not as well. So hopefully that answers that question there as well. So I'm just mindful for time. What I would say is that if I've not gotten around to your question, I do apologize. There is quite a few questions that came through. You do have that complimentary legal consultation that you can look to book in after this webinar ends. A saver will pop up where you can look to book that in, and you can book in some time with us to have that discussion about how we can support you with those particular needs and also with anything else, whether it's employment contracts or otherwise. I would also be really grateful if you could please complete the survey that end does pop up after the webinar ends as well. We would really appreciate that. But otherwise, thank you very much for joining me this morning. Hopefully, it has provided you some useful information on how to sort of deal with mental health in the workplace. But as I say, if you have any additional questions, do book in that complimentary consultation and we can touch base further upon that. Otherwise, thank you very much from everyone here at the LegalVision team for joining us today.